B, C, D, E, F, G, H, I, J, K, L, M, P, Q, R, S, T, U, V, W, X, Y, and Z. Now, why not fly A, B, C? Next time, won't you sing with me?
Plyler v. Doe, 1982. The circumstances leading to the case of Plyler v. Doe began in 1975, when the Texas legislature passed policies allowing schools to exclude children of undocumented aliens from public schools and to withhold district funds for the education of those children. A class action suit was brought against Superintendent John Plyler and other school officials on behalf of several undocumented Mexican children in Texas. A federal court ruled the state had violated the 14th Amendment, which guarantees equal protection under the law. The defense appealed. In 1982, the Plyler v. Doe case reached the Supreme Court. To understand how the court examined the case and reached its decision, we have to understand the cases of United States v. Caroline Products Company in 1938 and Graham v. Richardson in 1971. The U.S. v. Caroline Products Company set the precedent of applying strict and critical review, also known as strict scrutiny, when looking at cases affecting suspect classes. Those are groups in which membership is based on immutable characteristics. A state must have a compelling or substantial interest to have its legislation upheld. Graham v. Richardson established that alienage was a suspect class. These two cases meant that for Plyler's defense, they had to show that the state had a compelling interest to exclude undocumented children from the public schools. In a close 5-4 ruling, the Supreme Court affirmed the lower court's ruling. The court had decided that even if the state found it expedient to control the conduct of adults by acting against their children, legislation directing the onus of a parent's misconduct does not comport with the fundamental conceptions of justice. But the court had not simply decided that the state of Texas violated the 14th Amendment. The majority opinion concluded that public education was too important to be denied to a specific group of people. In the majority opinion, Justice Brennan wrote that education provides the basic tools by which individuals might lead economically productive lives to the benefit of us all. In sum, education has a fundamental role in maintaining the fabric of our society. We cannot ignore the significant social costs borne by our nation when select groups are denied the means to absorb the values and skills upon which our social order rests. So how does the decision in Plyler v. Doe apply to us now? Especially in times when immigration and undocumented students are contentious issues, it is important for schools and educators to know the rights of those students. Plyler v. Doe says that these undocumented students must be served and cannot be excluded based on their immigration status. Schools and staff cannot inquire into the students' or their parents' immigration or citizenship status. They cannot require any documentation showing that status, and schools cannot engage in chilling practices. Chilling practices are any actions which create an unwelcoming environment for undocumented students. Educators are to create an environment free of suspicion. Teachers and schools are not legally obligated to enforce immigration laws or to provide information on students' immigration statuses to any outside organization. Doing so would also be a violation of the Family Educational Rights and Privacy Act. Educators are to create an environment which does not subject the students to racism or promote misinformation. The school and classroom environment should be hostile-free. Ultimately, schools and teachers complying with Plyler v. Doe will serve students well and equally.